may I kindly see 135,
Look at the findings at 38.
para 38.
The issue, do plaintiff do without consent of the transfer?
Well, this is about 50, Article 59, Malad. I'm not even relying on
Whole
59.
Your whole
50.
case is
58, Malad.
that unilateral act.
Malad, correct. 50.
Everything is that I think your whole case is now relying on that I can unilaterally transfer it, have transferred it.
Whether, Malad,
The court found, it is entitled to find out, the court found that all that is not true. It is a plea taken for the purpose of defeating his rights. These are the findings.
No, Malad.
These are the findings, right? At least.
These are the findings. Yes.
Whether right or wrong.
Correct.
These are the findings of fact. So virtually now you are asking us to take a second opinion.
Malad, what did the trial court say, Malad? The trial court held in my favor.
Last court on
articles, Malad.
Last court on fact.
Correct. Last court
is the
fact is the Malad, the
appellate court. High court only affirmed it.
Correct. Now, Malad, the question is,
you will have to get over that.
Malad,
you will have to get over that.
If I am able to establish that Article 58 gave the company the power, Malad, to unilaterally transfer.
Assuming.
Right.
Assuming that there is a power.
Yes.
Following that power, whether you have acted in consonance of that is also a big question which they formulated and said all that plea and stand that you have taken is fraudulent is the finding.
Well, that
then
on what basis? There is no.
It's a different matter.
Reading. Where does he get this finding from? Malaj is the question that I ask.
So therefore, we come to the point.
Yes.
That whether the finding of fact is correct or not according to you.
Correct.
The finding why should we get into a finding of concurrently both the courts have done? So we have come back to a question of fact, Mr. Pragyan.
That's right. That's right.
So it's no whether in furtherance of the so-called power, you acted in consonance with. But you are asking us to say, examine that there is no fraud. Then again, it's a question of fact again. All go.
But the difficulty would be, Malaj, and also Malaj.
Pura fact.
Correct, Malaj. Before that, Malaj, Lordship still.
We are
one more finding of.
See, pin you down.
Malaj, may kindly see page paragraph.
I find no merit in the contention of consequent resolution of the company.
Transfer. Today, can
that's
seek
not
the
the
share
way.
certificates.
When you take a plea that I have passed a resolution.
Yes.
In furtherance of that resolution, this is what I have done. Then the burden is on you, not on him.
Well, the trial court says that.
Let's see where you have argued all these points.
Well, before the
High Court.
Because yes, I have argued. Lordships will see the High Court order now. Before that, I was just wanted to show one paragraph in 135, Malaj, of the trial court, Malaj, of the appeal court, page 135, para 50.
What?
Last sentence. Furthermore, the act of unilaterally transferring the shares.
Para 50.
Well,
135 para 50.
Para 50.
No, it doesn't say so. The plaintiff.
The plaintiffs, I'm reading the last sentence of that. The plaintiff succeeded in proving that he was holder of 3,500 equity shares of defendant number 1 company and 1,010 shares of defendant number 2 company. By virtue of amalgamation and merger of defendant number company, so-and-so became entitled to 18,900 fully paid up shares of the defendant number 1 company. Furthermore, the act of unilaterally transferring the shares held by the plaintiff to third persons is per se illegal and not binding upon the plaintiff, Malaj. Then it is a case as far as purely under the Companies Act, Malaj.
Inured to him are matters of execution.
Correct.
So, in a best for you is that in the execution, take the plea, what exactly will be entitled to, and ask the executing court to consider that. Before that, we will permit you to show us the High Court judgment also.
Yes,
whatever you want.
Lordships will see the High Court order, Malaj. That starts at page 1. Malaj, finding starts at page 9, para 14.
It's very clear. They have said the terrible of the
Yes.
share transfer.
Lordships will see para 15, last sentence, Malaj. relying upon Article 58 extracted herein above, Mr. Nayak, Lordship has para 15?
Para 14 onwards, if you want to.
Lordship has para 14, my lords?
Page 9.
Mention two things that the article of association will be over the 108 into not in contradiction to it. And
No, the Article 58 is not in contradiction, contrary to 108, my lords. So I can definitely have an article, my lords, even though, my lords, and that article will, my lords, supersede any provision of the Companies Act also, my lords. That is settled law. One. Two, your lordships have held that in that, my lords, that SEBI, my lords, CLB order, my lords, and my lords, what was that judgment? IFB Agro, my lords, your lordship's judgment, sitting with Justice Bopanna, my lords. Lordships have held that if there is a special act, the provisions of that special act will apply. If that be so, now the appeal court specifically states here, my lords, that it is a matter of transfer of shares. And he says that the transfer was illegal. So if it's a transfer and there is an illegality as far as the transfer is concerned, the entire jurisdiction as far as, the challenge is concerned is before the court under the Companies Act, my lords.
Civil court.
Well, there's a specific bar, your lordship knows that specific bar is there, my lords.
But the situation here is not a issue of it's a little high-handed.
Well, there is
That is why a retired man was
everybody,
supposed to go to the
each and every person who
What will
retired.
happen? Just think, you incentivize people to join companies,
Well,
give them shares,
each and every.
and as he reaches the date of retirement, he says, "Sorry, I have taken back your shares. You take this little money and walk away."
May I say this? During that time, and there are judgments as far as the CLB is concerned.
This maintainability issue, everything they will consider.
This was an uniform kind of a
David.
clause, my lords.
You will not say anything about the share part of it, about the execution part of it. It's better that we leave it while, okay, heard Mr. Pragyan Sharma,
My lords,
learned senior counsel.
they have already filed an execution, my lords. Then in that case, my lordships, I'll withdraw the SLP if your lordships permit.
Itni there are you करने.
After so many years, my lord, but this is appeal, sir.
1 minute. Well, lordships will, no, I mean, I think, yes, well, lordships will pass something, my lords. Whatever.
Yeah, you don't take it on your head.
Of course.
Heard Mr. Pragyan Sharma, learned senior counsel, appearing on behalf of the appellant, assisted by so and so. Having considered the matter in detail, including the jurisdictional questions that were raised, we are of the opinion that the findings of fact as arrived by the first appellate court are correct and do not warrant interference. We are also satisfied with respect to the preliminary issues as were considered by the first appellate court in the High Court. In this view of the matter, appeal fails. Accordingly, appeal number so and so is dismissed.
Grateful.
We also, I will clear is there, when was it admitted?
My lords, it was admitted, my lords. There is an order, my lords.
Naturally.
May I just give that order?
Okay. ऐसा लिख लेना. Mr.
Lordships will see.
also heard Kasina.
Leave granted on 16/12 when.
We have also heard Kasina, assisted by so and so. ठीक. Thank you, Mr.
Great.
Your best luck is execution.
Execution.
1 minute, there's some amount deposited here
Yes, my lord. That may be released, my lord. Then.
in his favor.
To him.
The amount deposited before this court shall be released in favor of the defendant.
Without prejudice to my rights, my lord, so that
What more rights? We are not saying it.
no. My lord, what they will do, my lord, in the execution, that since you have accepted it,
No, nothing.
That is the court deposited the court and your
So
district.
permitted to be released subject to final outcome in the execution
my lord, fair enough.
proceedings.
Fair enough.
Great.
It was a simple solution for a company like Praj. But anyway, my lord,
Even now we were thinking of asking either Mr. Guru Krishna Kumar or Mr. Sharma to mediate. No, I'm saying those two senior counsel standing behind you. We thought of asking them to mediate. All right.
There's a limited company, we can't give
Then-
more than the value of today's market value.
You can raise this plea in your EP.
Yes, of course.
Unsolicited advice.
Please, Lordship.
Yes.
Lord, 103 is 103.1 till 103.40. They're all connected.
Whatever.
Yes, Lord. Your Lordship will see, Lord, the issue as your Lordship would.
10. So small matter only, na?
Yes, sir. Should not take more than that.
Just on delayed payment.
Oh, interest on delayed payment.
Yes, my Lord. Interest on delayed. In fact, my Lord, interest
But
on.
this matter is pending, I think, on this issue. Justice,
I tried to find out.
Justice Sanjeev Khanna brought this issue to a larger bench, if I'm not.
Because in these very batch of matters, some SLPs were dismissed. Then, my lords, one matter review was filed in which notice was issued. But all of them ultimately have been put together. Some SLPs have already been dismissed on this very issue. The same.
Different matter. The question of interest part of it. But
Interest.
The only issue in this case is interest.
These cases pertain to, my Lord, where the amount stands paid.
you are all clear that Justice Sanjeev Khanna has not referred that interest part of it to a larger bench.
My Lord, I am not.
No, I don't think so, my lord. No,
I'm
no.
not too sure. I would be, my Lord, wrong to say that I'm sure.
But to the best of our knowledge, my lords, there is no such reference.
There is an order, my Lord, here in one of the SLPs where, my Lord, Justice Khanna has, my Lord, while issuing notice, directed us to place on record a calculation sheet to show how the amount is calculated and how the amount has reached the humongous figures that have been awarded. That item number, my Lord, in fact, my Lord, we had filed a detailed
The problem with MSME.
convenience compilation also. Because, Lord, here's a case where, Lord, in most of the cases here,
Doesn't matter, you argue.
yes, my Lord. My Lord, most of the cases here, my Lord, whatever the invoice values were, whatever the, my Lord, bill amounts were, my Lord, they stand duly paid.
As per the court's order or?
No, my Lord, as per, even before they went to court.
Show us the act.
Here-
Get the act, please.
Yes.
MSME Act.
My Lord, may have, my Lord, both these acts are pari-materia, my Lord, the interest on delayed payment and the MSME Act, except for change in numbering of the section, my Lord, they
The
are,
relevant section is the identical.
my Lord, they're absolutely identical.
Which section is that?
My Lord, under the MSME, it will be section 15.
Under the old act?
15.
Just to take 1 minute, I'm so sorry. The reference, what my lords were pointing out, my colleague tells me he just got that order. It's not on this point. The reference is on
The registration.
2-3 questions. I'll just read them. Lords. Whether the ratio in India glycols that a writ petition could never be entertained against
writ
any
matter.
order
That's a writ
of the MSME council. That is one. Then if the bar and prohibition is not absolute, that's on maintainability of writ petition. Those are the first 2 questions.
So these three are referred to CV. That's after my judgment.
Right.
And, that is another. When we referred that Shilpi judgment.
Oh, Shilpi.
goes. Read that second question. I'll tell you.
NBCC.
Ah,
NBCC, I believe.
That's how they.
Let's check that. So the first 2 questions in this are with regard to writ petition, maintainability.
Third,
Then third, my lords, is with regard to disqualification of members of the council who undertake consultation upon failure can themselves act as arbitrators of the tribunal in terms of 18 of the MSME Act. Then, my lords, that's about it. These are the 3 questions. The third is with regard to whether the members who undertook the conciliation can act as arbitrators and hear the matter.
doesn't matter. It should get over today because the bench is going to be only for today.
It's a very short question.
Try.
There's no trying. There's no trying. There's not making.
Either you have to complete it or.
There are barrage of seniors on the other side, but I am the.
All right, I'll eject myself out.
That's it, my Lord. The Lordship will see, my Lord, in all these cases, my Lord, the principal amount of invoices stands paid even before the proceedings were initiated.
Operation of the act, we'll have to see there are no equities in this. Whatever the section says, the section.
Absolutely, my Lord. In fact, my Lord, the Act is silent about interest on interest. That's our, my Lord, gravamen. Kindly have, my Lord, 15.
What is the section?
My Lord, 15.
You are asking.
My Lord, 15, 16, and my Lord, also 17.
Okay, read them.
Yes.
Section. Complete your
Time. Delayed payment to micro and small. So this deals with, my Lord, delayed payment. Liability of buyer to make payment. Where any supplier supplies any goods or renders any services to any buyer, the buyer shall make payment on or before the date agreed between him and the supplier, or where there is no agreement in this behalf before the appointed date, provided that in no case the period agreed between the supplier and the buyer in writing shall exceed 45 days from the date of acceptance or the day of deemed acceptance. So under the earlier act, we were 100, they brought it down to 45. Now, Lord, 16. Date from which and rate at which the interest is payable. Where any buyer fails to make payment of the amount to the supplier as required under section 15, your Lordship may mark this, my Lord, payment of the amount. The words are payment of the amount. As required under 15, the buyer shall, notwithstanding obtained in any agreement between the buyer and the supplier or in any law for the time being enforced, be liable to pay compound interest with monthly rest to the supplies on the amount from appointed date as the case may be, from the date immediately following the date agreed upon at 3 times of the bank rate notified by, just for a second, my Lord, where it says amount due to the supplier. And 17. Now, my Lord, 17 talks about.
Oh, 1 minute, 1 minute.
Yes, my Lord.
Pay compound interest with monthly rest to the supplier. On the amount.
Yes, my Lord. My Lord, we'll have now 17, sorry. Now, here also the word is recovery of amount due. For any goods supplied or services rendered by the supplier, the buyer shall be liable to pay the amount with interest thereof as provided under section 16. Now, my Lord, 18 talks about different modes. My Lord, you can go to the facilitation council, my Lord, you can file a suit, you can also go in for arbitration. So, in our case, my Lord, the amount due, which was the, my Lord, the invoice amount, in all cases across board, my Lord, stood deposited before the proceedings were initiated with a delay of, my Lord, about 7 days to maybe in some cases about, my Lord, 7 months.
Give us the dates. Give us the dates.
Yes, my Lord, I'll give the date.
Okay. Calculation of interest.
Invoice dates are,
ये amount कौन
the orders are placed,
payable होगा ये not
my
interest.
Lord, between 1995 to 1996.
इनका argument इतना है
यही है कि we for the make the payment, we have to make the payment.
Yes, my Lord. My Lord, purchase order cum contract agreements were entered into on 14th of August 2000.
contract.
Yes, my Lord. During that period, my Lord,
Contract or purchase order.
yes, my Lord, purchase order. So it's called purchase order cum contract agreement because, my Lord, the series of supplies, series of, my Lord, powerhouses located pan state. So some is meant for some state, some is meant for some state. So it's an ongoing process.
Anyway, the contracts were entered into in 14/8/2000.
14/8/2000.
Then supplies.
And thereafter, my lord, the supplies were made till about 2002.
From when to 2002? From 2000 to 2002.
Yes, my lord.
Then,
So, my lord, thereafter, the payments were made in different cases. Like I said, my lord, delay of making the principal payment 7 days. In some cases, from 7 days to about 7 months in making the payment. But all the payments in 99.9% cases were made before, my lord, the claim was filed.
no, that's a claim is a different matter.
Yes. So, till
The
filing of
amounts
the
were
claim-
paid within 45 days.
No, in some cases, my lord, post 45 days. But within,
Did you make a chart somewhere?
my lord,
Which case you have deposited on, which was the date for this making payment and what was the delay?
my lord, I will. I have
In all those 40 cases,
Amount has already been, those were paid after the period which has been prescribed.
after 45.
45 days.
Yes, yes. After 45.
That is, he is admitting. That he is admitting.
Yes, my lord. After that 45-day period was over. Right. No, but in fact, this was 120 days under the old act, like I had
Doesn't
said.
matter.
So, but even after 120 days, that 120-day period buffer was over.
So, let us say if the amount was about a lakh of rupees, 45 days will get over by 31st of March,
Yes, sir.
and you have deposited the money in, let us say, October, right?
Yes, my lord.
March.
Your lordship may presume October, but that's deposited.
7 months gap is there.
7-month gap.
So, for that 7 months delayed payment,
Yes.
16 will apply.
Yes, my lord.
That's your case.
That's my case, my lord.
What's their case?
Not their-
What was held against you?
My lord, what was held against me, my lord? 1.5 PLR at monthly
That is-
compound.
the way to calculate is
Yes.
that
Can I-
over and above that.
Yes, my lord. Sorry.
So for that 7 months period,
Yes.
the interest that is payable is the bank rate
Yes.
multiplied by 3.
Yeah. With monthly rest. Compound.
How does that? Acha, okay.
Blood compound.
Monthly, every month compounded, is it?
Yes. Every month. Which is why, my lord, a claim of interest on interest, which was up to 19 lakhs, my lord, after the claim was decided, after a couple of years, reached 87 lakhs.
Three
And
times.
thereafter, my lord,
You are saying then what's the point in using this expression by to pay there are two expressions, you should answer that.
yes.
Compound interest is one expression, monthly rest is another expression. There must be having some meaning if they have used it.
My lord, the meaning is, my lord, attributable to, my lord, the capital need aspect of MSMEs. And
Whatever, how do you, they use the specific expression compound interest. Compound is permissible with monthly rest.
With monthly
that's
rest,
permissible.
the supply,
That's
the amount.
permissible
The
as far as the principal
What
is
is the case?
concerned, till the time it is paid. And also, my lord, for the interest,
How does it operate? How do you calculate according to you?
my lord,
Tell us,
according to us,
taking into account the compound interest expression.
Yes,
How do,
sir.
according to you, tell us.
my lord, according to us, the compound interest ought to have or could have been calculated as interest or interest for the delay in making the payment, which is like, let's say, for 7.
So let us say if the bank rate is about
Not throughout the adjudication, my lord, till to finality.
let us clear upon. If the bank rate is 9%,
Yes.
right? To that 9% multiplied into 3, eh? 27%.
27.
So therefore, on that 1 lakh for the first month,
Right.
27% interest you levy.
Yeah, 127.
And
1
lakh
127 again, my lord, 20
for next month.
for next month, and that gets added, and then next month, and that
Then they calculated how much they arrive at.
my lord, is reached more than 200 crores, my lord, or about 100 plus. And your lordship will see, my lord, the facilitation
How else
council.
do you interpret? Of course, it's been a concern of all courts on this. Sure that MSMEs are not starved of funds.
Exactly, my lord.
And in our judgment, we have said how important MSME is. That's
Absolutely.
the backbone of our country. And because they are weak people, companies don't pay and they die. That's the reality
That's the
of
reality.
MSMEs.
But this case,
We have said that in one of our
I did
judgments.
go through it, and your lordship judgment in D. Khosla also I read, my lord. Where lord, D. Khosla's judgment, where your lordships have said that interest on interest is not, it has to be, my lord, forwarded, it has to be supported, backed by some law.
Okay, we are referring to our judgment in MSME. That's a different judgment. लेकिन तो बहुत जाना है, हमारी जाननी ज्यादा है, लेकिन
मतलब completely, my lord, ignores it. In fact, I'll
not ignored, it must have given effect to what the
But
parliament
can I
said.
just make a, my lord, I have given a convenience compilation in two set of appeals. So your lordship will have to, my lord, go left, right, as far as my lord, the humongous files are concerned.
Interest.
कैलकुलेशन पे रेफर करो कन्वीनियंस को देखें कन्वीनियंस फाइल करिए इसमें
अलग से फाइल करिए
अलग से फाइल करिए इसमें नहीं है फिर अलग से फाइल करिए दिस इज फॉर एआर गिव देम एन एग्जांपल 87 हमारी कैलकुलेशन में से कैलकुलेशन में ये नहीं
Mr. Courtmaster, we filed a calculation sheet like this in terms of the direction. No, but there was a direction by Justice Khanna also to show how that calculation has been arrived at. That's there, my lord. Yes, my lord, the High Court. Yes, my lord. Kindly see, my lord. Convenience compilation मिल गया? I filed in both the set of appeals. They are arising out of two orders.
No.
What is our item number?
40.
Plus, these amounts have shown so much humongousness because they defaulted with hundreds of suppliers. That's how the amount go up. It's not that each supplier gets some big amount.
I will show. Let me complete. I'll show you how is substantial.
How many matters are before?
40.
41. How's this दिखा?
Yes, it is there, sir. All this, Punjab.
हमने ना दो ऐसे फाइल करे थे.
Oh. All are you only?
1 and 2
Improved order देख लेते हैं एक बार. Mr. Sud, just read the improved order once.
Yes, my lord.
We'll just see.
Hila?
Why don't you read the improved order? क्या कर रहा है यार?
compilation only
क्या बोलता है improved order?
Page 5, sir. Start.
हाँ.
4.
Brief them. Paper would do though. So we are concerned about
9980. Your lordship has the CA number.
अरे ये बोलो because of this taxpayer has to pay an amount of 9 total in all 40 to be 34 lakhs.
Take the impugned, please read the impugned order,
I'm starting.
page 8.
Now, the brief controversy between the parties is that the claimant respondent filed.
Page 8, page 8.
Yes, bro. Original file में से निकाल दो. Brother, your
No,
lordship.
even you can skip that. Come to page 10, learned counsel for the appellant.
Current counsel for the appellant has argued that Act of 93 has prospective application. When the supply order is made prior to effective date of the Act has no, 93 Act has no application. To support his contention, he has relied upon the authority of the Supreme Court in Shakti Tube versus State of Bihar and others. I am of the view that matter whether the council has jurisdiction or not has already been discussed above. It is held that the council has jurisdiction. Moreover, the interim award has already become final between the parties and cannot be reopened, particularly when the same is not under challenge in the present appeal. The counsel, the appellant has argued that no effort was made by the council to affect the conciliation between parties.
1 minute. Interpretation, that's all. We are not going to touch this.
No, but they have not raised even before the High Court. I can gather.
But then it will arise in execution, I think. Your issue.
Yes, Lord, they were not because the.
No effect is made in the council to effect the conciliation. These are all merits of the matter.
Yes, Lord.
The authority in the case was fine.
But this court issued a
On the
limited.
other hand, counsel for the respondent. Okay, counsel for the respondent relied on this signal. Here, page 12, I think.
Yeah, not.
Higher rate of interest under the act.
But this court issued notice on the aspect of interest.
Only
But,
interest.
where you have, this question was raised by you that this interest can't be charged as per this
Right.
before the High Court, sir.
Before the High Court, not directly, but
No, but interest, what interest is payable and so on is an issue which will arise in execution. How does it arise here? Your challenge is about 34.
my challenge is also on the interest aspect.
But sir, you have not challenged it before the High Court.
But before the High
The High Court you have not challenged. The High Court has not expressed any opinion. Then
No, you are saying that question was not raised there.
not raised.
Where is your 37?
Yes, Lord.
Where is your 37?
Because
Is about 30 is about arbitration.
About arbitration, one more thing, my lords, in our matters, in fact, most of them, calculations were called for by the council during the arbitration as an interim award. We gave calculations. They did not give.
yes, that is there. They have recorded.
They did not give.
No,
They,
given, not given. Shows the operative portion of the award.
yes.
Award being paid here.
Please see.
Yes, Mr. Sud, let him show it. Let him show.
Lord,
Shows the operative portion of the award.
yes, Lord. The award is at page number 33. 33, Lord. P1.
Shows the operative portion of the award with respect to interest part of it.
15. 39. Page
39, no?
para 15.
Accordingly, award for rupees 2 crores 40 lakhs. This amount has been calculated to interest payable up to a copy of the award is sent to both parties, provisions of the arbitration council.
Lord, it reads from para 14, in fact. I'm sorry.
Para?
14.
Okay.
Page 39.
Yes, sure.
So, my lord, both
Read.
both were directed to give up.
You read.
The-
You have not disputed that.
Yes, the claimant published their calculations for crore 33 lakhs, copies of which were supplied to the respondent. Respondent filed the counter calculations signed by the purchase officer, Patiala, in which they found discrepancies and they calculated the amount at 2 crore 40 payable up to 15,711. And the copies of the same were supplied to the claimant through counsel. Opportunity was given to them to verify the correctness of the calculation submitted by the respondent, but the claimant, despite being an opportunity, failed to point out discrepancy, rather admitted calculations of 2 crore 40 lakh submitted by the respondent to be correct. So both the parties are not at dispute with regard to calculation, and the calculation by the respondents have been admitted to be correct by the claimant. And as such, the award being passed per calculation submitted by the respondent according to award of 2 crores 40 lakhs is passed with costs in favor of the claimant against the respondent along with future interest, which comes to 19.5% per annum with monthly rest from 16/7 to 11 till the date of realization.
Sir, that's right. Now, where is the, which ground you have taken that this interest part or calculation of interest part or whatever it may, where is that, sir?
That interest ground was taken, but not so happily worded.
No.
Delivered, you
34. Show us 34 at least. Show us at least 34.
34 is
However, unhappily it is worded, show us in 34. 34 is not before us.
in fact should be in a convenience compilation that I filed.
41.
Filings were done.
Sir, you have simply challenged before the, you have not challenged this finding, this part of the, this finding of the tribunal before the High Court.
In fact,
34. Sir. 41 देखिए.
41. It's 34, yeah.
Page 43 में.
Yes.
Where did you say that the interest calculation is wrong?
I'm just looking for 34.
Page 56 में. 56 bottom. नहीं कुछ नहीं. This court has actually, as this court, is there a judgment about interest of this court in MSME?
No, my lord, nothing.
There is one judgment of my lords where the scheme of the act is discussed on who this operates.
NBCC.
Not in, that is the referral, I think, my lords. This is generally that we discussed the other day.
Innovation, something.
Purvanchal is much earlier. But you know,
No, actually, अगर award दे देता है
NDCC.
वो कह रहे हैं
Yes.
उनके बाद.
Just take it out. Yes.
क्या पढ़ाया था मुझे भी.
Page 39 is that the award grants 19% interest, correct?
That's it.
That's what you're saying. Is there any reference in this award that this 19.5% is granted in terms of MSME Act or in terms of a contract? What has it done?
Lord, because it says 19.5% monthly rest 3 times.
That is how it calculates.
That's how it calculates.
All right. Anyway,
And
in that list, you're prepared in each of those batch of matters. What amount has come to what amount have you?
Yes, my lord.
How much have you paid till now?
In fact, we
Now
paid,
paid.
one second, one
They have now paid
question-
pending the proceedings.
Question.
Entirety.
Yeah, they are paid.
Guru, one second.
Oh, nothing
Lord,
is
we
made.
came-
They have already paid.
One second. Lord, we came before this court. We came before this court. This court was not pleased to look into the aspect and issue a notice limited to the aspect of interest, that how the interest has been levied, because the principal stands paid. In a delay of 2 months, you might give, my lord, the interest as stipulated.
Appellant will deposit. So you all gave BGs.
Yes, so all gave BGs. 75% we paid in 2016. My lord, that's the requirement of the statute, that no 34 will be heard till the time 75% is not deposited. And thereafter, directions of this court, my lord, the rest 25% were paid, subject to, my lord, they are issuing equal amount of bank guarantee.
Question of law in some other case.
No, my lord, this case would need your lordship's attention, my lord, because this is one of its kind. My lord, there is a limited delay. There is a limited delay.
During the delay, during the pendency of the post-pen.
Is gone.
My lord, this,
Except that the BGs are subsisting.
yes, my lord, this is subsisting.
Only the BGs are subsisting.
The BG
Otherwise, the amounts are paid.
The amounts are paid, my lord. And they were paid on this condition.
Suppose we say that, okay, interest can't be 19.5% and reduce it. Or you will go and recover from them.
My lord, in terms, their properties are lying with us.
BGs are there.
Their properties are lying with us, my lord, in terms of the directions of the Supreme Court. It's on that specific direction that only they were released.
What will be the difference?
My lord, difference will be, my lord, even if,
Out of what a reasonable interest and
my lord,
the amount that you have paid them.
my lord, let's say,
Putting all put together, how much is the money for you?
my lord, all put in together, my lord, I have given a calculation, my lord,
200 crores, 500 crores, how much?
Paid 123 crores.
on a 44 lakh,
4 crore.
4 crores,
Total claim in 40.
total claim in 40, my lord, we have paid 123 crores. Your lordship, I'm a public sector, I will go completely, my lord,
Nothing.
bankrupt.
You already paid.
123 crores, my lord, out of a liability of 4.
You already
And
paid.
also, see, my lord, I just want
So you would have learnt your lesson. Have you learnt your lesson?
no, my lord, in fact, I would,
Not to delay payment of MSME.
my lord, payment is not delayed. It's the 2 months, 3 months, 4 months delay in
The
making,
delay is there, sir.
which attracts
One second.
interest as per the statute. But, my lord, where once they go to the facilitation council and award is passed, my lord, award also, my lord, till it is recovered is 19.5%. During the adjudication,
No, facts though, facts. What, okay, tell us, impress us on your interpretation.
yes, my lord.
Just leave everything aside. Tell us what your interpretation. How do you want to interpret?
So, my lord, if your lordship will see,
Just take the bare act in
Just
your
the
hand
bare
and
act.
don't argue anything else.
just the bare act. I'll try and, lord. So, your lordship has seen what 16 says, my lord. I'll read it again. It talks about the amount to the supplier. If your lordship will permit me, my lord, where any buyer fails to make payment of the amount to the supplier. So, my lord, the amount to the supplier, my lord, has to be, because it's at a stage where it is not paid, has to be construed, my lord, as the invoice amount, the amount due under the purchase order. So, that is the amount as required under 15. Now, 15 also talks about liability. It is, my lord, prepayment stage.
Okay. Till there is no problem. Till that point, no problem.
Yes, my lord.
Further,
I'll just try and satisfy, my lord. To make payment of the amount to the supplier as required under 15, the buyer shall, notwithstanding anything contained in any agreement, so, my lord, that's also not really relevant. And come to, my lord, now the recovery of the amount.
liable to pay.
Yes, my lord. Compound interest with monthly rest on that amount. So, my lord, on that amount, if you refer to the the section prior to
So
that,
month after month,
yes,
19.5%, not 19.4%.
Yes, my lord.
Whatever is the 3 times the bank rate, let us assume it will be 12%.
yes,
If the principal payable is a lakh of rupees and there is 6 months delay on 1 lakh, 12% In January, 12%. In February, 12% on the
Roughly
principal only month
2
after
lakh.
month.
Matlab roughly
But
2
it
lakh.
can't be 1 lakh, 1 lakh 12,000, no, 1 lakh
Plus 12,000 and then
12,000
1
and
lakh
then
2,000.
24,000 like that, whatever it
It'll
is.
keep adding. Now that has been ordered till the date the payment is made. My lord, 7
Then
years.
but then see, or else it would have been per annum.
Could have been per annum.
Per annum, but then use the expression compound. How do you understand compound then?
Lord, I will say is a case where
What you are asking us to do is delete compound.
I'm saying use compound, my lord, for the period of delay.
कहाँ लिखा तुमने उसमें नोट्स और कहाँ जाओ
Use it about previously. During the not during adjudication, where it takes 7 years to decide this matter.
Well, I'll say I have not.
We have seen cases, yours are actually small amounts. We have seen cases, the public sectors will collapse. We have seen instances where, but then that's the parliamentary intendment. They didn't realize the consequence of this. Or perhaps they have realized and said that come what may, let the companies close down, or it will have such a serious deterrent effect that they will not keep on arguing this case and
My lord,
postponing the case from
Facilitation Council took 7 years to decide.
Whatever it may be, but sir, ultimately, you have also not challenged the validity of this section.
You are right. You are right. Actually, you are absolutely
Lord,
right. The solution in all these matters is effective. That is also in one of the judgments we have said. We have directed the facilitation councils, how they must be constituted, what is the obligation of the duty bearers there. We have mentioned about how the system should be worked very well and efficiently. In every case, the problem is that the remedies don't work. Your problem is the remedy won't work.
And my lord,
The best alternative for you is pay the money and litigate. Then what will happen is that you don't need to pay subsequently after you lose the case. Pay the money and litigate.
the money is already with them. Now your lordships have to decide, my lord, whether the calculation of the interest.
We will keep this question open-ended. We don't want to. We see some sense in the seriousness of the section, but we will not give a final decision on that. We'll close this.
Can I only point out one thing, my lord? My lord, equal to that, now, my lord, the facilitation councils have started, my lord, denying that interest.
That's another thing.
2012
The agreed party will come there, sir. They will come there.
My lord,
Third, Mr. Sood Leonard, Additional Solicitor General.
a former.
Senior counsel on behalf of the appellant corporation. In view of the concurrent fine, because it's silent on interest part of it, in view of the arbitral award being upheld in section 34 jurisdiction as well as the 37 jurisdiction, we have not found any question of law that would engage our consideration. So, having considered the matter in detail, all these appeals stand dismissed.
Question of law is left open. Something, my
The
lord.
question of law relating to interest raised by the interest. The question of law relating to interest on the interpretation of section 16 is kept open for being considered in an appropriate. Okay, the question of law relating to interest payable under section 16 has not been considered by the High Court. In this view of the matter, the question of law is kept open for being considered in an appropriate case. High Court has not considered it. What's the problem?
Nothing.
The one which is there. Item 15.15, there is a difference of calculation and I have moved an application because the official wanted, I will do it with the.
EP.
I said, let leave that, because that should not come to an end. I'll leave it, that if, that will be, yeah.
We say nothing.
Point one.
We say nothing. What do you want us to do?
It is, the amount, the total calculation would be left open to by the existing code.
That is
You
always
have not
there.
said anything. You have not said anything. You have not said anything on the merits or calculation or in the EP.
Thing is, but if you propose,
So we have simply dismissed their SLP, that's all. Nothing, they have not done anything.
I only, when my application is pending in, before executing court already, there is already, only in one case.
You present me.
Obliged. Only one SLP, my lord, which is 103.16, which is, my lord, as your lordships have held in Shanti, where the claims are obsolete and the claims are beyond that period, has not to be, my lord, taken into consideration. That SLP takes into consideration that aspect also of Shanti. This is item number 103. This is Guru Nanak Electrical. So, my lord, that your lordship will have to, my lord,
DTAG.
and also, my lord, look at it because it's covered by a covered judgment of the Supreme Court.
Which says what? The registration of MSME.
Not there, the POs are prior to 92.
POs means?
Purchase orders prior to 1990.
Shanti.
Yes, Shanti.
Yeah.
No, my lord, your lordships recollects, I had argued that one day before yesterday on Saraf, where your lordships had taken into consideration the interest on delayed payments on the SSI prior to 1990, and lordships had dismissed their own SLP, appellate was the same.
All 40 is the same.
Same order.
Yeah.
Dismissed. No, it doesn't matter.
That's also a substantial claim.
Leave it.
Grateful.
Big matter, small matter.
It's actually, in this matter, kindly recollect on the last occasion, Islam Court directed me to especially look into the effect of multi-state cooperative societies and whether it becomes state cooperative society on that aspect.
Correct. Union. We
Yes.
specially asked you to
Yes,
come and
yes.
assist.
So anyway, I'm not getting into the list in the particular matter, but on the
you
question
don't
of law, there is an earlier judgment report, kindly make note of it, I'm giving the copy of it, 2009, volume 16, SCC 157.
2009, 16 SCC.
157,
Uh,
which held that it should be multi-state cooperative society.
okay.
However, last month, there is yet another judgment. No doubt it has referred to this judgment, but without dealing with that one. In civil appeal number 7050 of 2010.
7050 of 2010.
Yes, delivered on 15th December 25.
What did they hold? No, I thought we saw this somewhere. Property of the multi-level subject cooperative society, though originally registered under the statute enacted by the appellant state, stands transformed into a multi-state. So both these judgments are in consonance with one another?
No, that's one thing. And both the judgments, they are not considered section 87 of the Reorganization Act.
May I submit one? All
Wait, don't
No, I'm not
submit
getting
yet.
to your individual merits. Just I'm pointing out.
No.
He's not.
There's no dispute about this fact. The lordships have already decided this question in this very matter. That is, I would see the order.
7051.
Lordship would see the order dated 19/11/19.
Yes.
51 and 5 and 51. विक्रम नाथ का है
19/11/2019. And I'm not disputing this fact. It's a multi-state cooperative society and there's nothing to decide it. The lordships have already decided that issue.
All that your lordship did in 19 was direct the registrar to take appropriate action under section 95 to make the societies functional.
And in both the matters, section 87 of the Reorganization Act is not considered.
Section 87.
87 of the Act.
Okay.
Have a look at the section 87 of the Reorganization.
What do we do today?
So, but may I, this is what I am saying, Lord. The controversy is cut short and it is concluded by this order. Just have a look at this order. 1911.
Who is the contesting respondent?
Interesting.
No, there are two sets of societies now. Not one part is in the territory of Uttarakhand, the other in the territory
Which bench heard it?
I'm sorry, ma'am?
Which bench? Who I heard it along with whom? Justice Alok Aradhe or
This was heard by
Justice Chandurkar?
no last occasion.
Yes, correct.
What bench? No, we'll have-
Justice Chandurkar.
Today, can we sit and close this matter today? Or we need to hear you?
I'm on.
So those two judgments are there.
Yes,
You be there to assist us.
I'll be there. I'll be there.
Because there is no contesting party and
Yes.
only we'll have to be guided by.
I think the issue will have to be resolved. I think ultimately it may have to go to the larger bench. That's what I. Yes.
Just leave it. It will be there in the list. It will not move out.
My friend may have whatever grievances we may have against the order.
Who is your friend? He has nothing to
No.
do.
Nothing.
It's
Not grievance, he's just only assisting us.
Right. The decision doesn't arise in this case.
Okay, all right.
Yes, sir.
We are not saying no.
And lordships have already adjudicated. We are not aggrieved. No one is challenging that. So all that lordships have directed is the central registrar to take appropriate action under the law for making the societies
So
function.
what happened after that?
Not from since 19. This is the third time which has come up, when lordships have been directing
The
repeatedly.
central registrar is not taking a decision on this, is what he's saying.
But whether the central registrar himself can do it as a multi-state cooperative society or it would be
Just
state
the direction of the-
that is one of the fundamental issues to be gone in.
Can you just impress upon him what had happened?
Very well.
We'll take it up. We'll just say not today.
Yes.
Because you also don't know because you're not a party.
Correct.
You're not appearing for any party.
Correct.
The problem needs to be solved, that's all. Whether it will remain as a state cooperative or whether it transit into a interstate, multi-state.
Yes.
To that extent, the decision needs to be taken at the stage or at the center stage by the central government.
Yes.
So it is in this context that he has made his submission.
Yes,
If you
sir.
just find out exactly the grievance, he will be able to take instructions.
My friend may take that. I have no difficulty in
In
that.
the meantime, can you have a
My
look at
friend
that
is
later judgment,
Yes.
which says that it should be state cooperative society. It should
We'll
continue.
have a look. We'll have a look.
But if
You
that
too
is so, Lord, we'll be very happy, Lord. We have no difficulty.
Have a look at it.
Have a look at it. That's all.
You too have a look at that judgment.
Comes back to us, Lord, we'll be happy to take.
Do it.
But
Not
then
good.
this, your lordship's decision would be a problem. Three-judge bench decision. State cop.
Both are.
But then that's not referred to in this.
No, that's cited. That is cited. However, they did not specifically deal with that issue. On a different angle.
That occasion, lordship wanted some help from my friend. Therefore, you lordship directed.
We will be there. We'll resolve this. Sir. It's an important cooperative society is a very important thing. Not today.
Very well. That's Lord.
Yes.
Good lordship is fixing a date.
So it's coming. Wednesday it will come.
Okay. I'm great.
This bench is only for today. That's fine. Big matter, small matter.
It's a batch of 56 appeals.
56.
Gift tax, income tax, wealth tax.
Not today. Not today.
Look, may I, in that case, request your lordship, look, we were the SSs, we were parties before the...
We're just not adjourning the matter. We're just saying not today. That's all.
Yes, my lord. We have moved some impleadment application. Look, those applications, it may be, your lordship may please to allow. We'll give the IA number.
We don't know. We'll see it.
All done.
We'll not pass any orders today. Just wait. Like
One request brought in the convenience compilation, some documents are missing. Permit us to get it.
prepare and get it.
No, we are given it. Some are missing. My colleague will get it.
Sure, sure.
One more thing. What
You're
happened?
just saying not today, that's
No,
all.
in this matter, one more thing is there's a connected matter in the Delhi High Court, and there the Delhi High Court has asked the parties to go for mediation. They're supposed to meet in Jaipur on 17th, 18th, 19th, and report the result on 20th.
Okay.
After that date, so that in case.
If all of you are agreeing in the mediation.
Yeah, point that I wanted to make, my lord, is my friend locals who actually have filed this appeal.
We will not hearing the matter.
But if the matter is already referred to the mediation,
We will wait.
then wait for that.
All the questions won't arise for mediation. The best part of mediation
I
is
just
that
thought I'd bring to lordship notice that though this is not connected, doesn't.
we are informed that parties have been referred to mediation and or private parties are referred to mediation and the proceedings are pending. In this view of the matter, a common request is made for listing these civil appeals after
20th, anytime.
20th of what?
20th February, we have to report settlement.
After 4 weeks. List thereafter.
Great. Permission to correct the record.
Yes, yes. Very well. 6.
Mine is 16.1, not 106, right?
We're being led in this matter by Mr. Gopal Shankar Narayan.
Don't say something. Let me finish first. Sir, may I?
We're seeking a passover in the matter because he's held up in court.
This bench is only for today.
Bench is only
He's
for
not.
one day.
I understand. This matter may also take some time. It's the MP reservation matter.
Yes, yes. Sir, finally it reached. Mr. Varun Thakur has been mentioning this matter every time, whenever we see him.
No, that's a different matter.
For a very, okay, that's a different matter, Varun.
No.
But, yeah. Sir,
Please.
may I say something?
Please, the OBC matter reservation in
Sir.
Madhya Pradesh. Excessive
Sir,
reservation.
the question is,
Today we will just,
no, I agree. But just hear me for just 2 minutes.
we are not adjourning. We are not adjourning. We are only saying,
I didn't mean to say that, sir. I meant,
just saying not today, that's all.
no, I'm not saying that at all. What I'm saying is, our case is not where we have challenged the act. We have not challenged the act. Our interim application is that against the provisions of the act, there is a notification. That's all. And we are not challenging the act at all. So if our interim application is there, because what they have done is, in some segments,